All right, welcome. My name is Scott Carpenter from the Carpenter Law Firm. We're live from the Carpenter Law Firm studios. Today's topic is the 2025 legislative update. In other words, what has the legislature done this time? The legislature has adjourned. First, I'm going to give you an overview of what we deal with at the legislature each year. And really, it's a story of stakeholders. Who's interested, who goes to the legislature each year. And what's stark about the list of stakeholders is who's not on it. We'll start with, obviously, community associations. That's the first stakeholder. And by community associations, of course, I mean the condominium associations, the planned communities, but not the boards of directors themselves, the volunteer members of boards that are really the engine of the entire world of community associations. They tend to not go. They leave the work to the rest of the stakeholders, management companies, homeowner advocate organizations. We pause here for an important reason. These organizations are self-appointed. Nobody designates them. They pop up from time to time and say they are homeowner advocates. And whenever I do these updates, for those who have heard me do them over the years, and I've been a volunteer lobbyist, unpaid, since I started representing community associations in 1994, they are dislikers of homeowners associations. Many of them live in associations, but they self-appoint as homeowner advocates, but they hate them. They believe that boards are corrupt. They believe, in many cases, that management companies are corrupt as well. And but they give themselves the label homeowner advocates, and this bothers me tremendously because we're the homeowner advocates of those of us who work every day in community association work. The vendors, the lawyers, the management companies, the professional community managers, we're homeowner advocates. We want communities to function well. We want them to be communities. We want them to be neighborhoods. Yet the ones who dislike and hate community associations receive the label homeowner advocates for no other reason than they give it to themselves. Lawyers or stakeholders, realtors, tend to get in on the action, get in on the meetings. The home builders and developers and legislators are increasingly lobbying from within. A legislator hears a story of woe from a constituent, becomes emboldened and frustrated about a topic. Maybe the legislator lives in a community association, has his or her own story of victimhood, of injustice, whatever you want to call it, and becomes a stakeholder. And what ends up happening is that when the legislature is in session, no stakeholder, no lobbyist can go on the floor. And the legislator moves around the floor of the legislative body, whether it's the House or the Senate, and becomes the best lobbyist for a particular position. So these are the stakeholders. Legislation in Arizona tends to work best through stakeholder meetings and consensus building, generally to facilitate the development of legislation. That's what happens. So there's a germ of an idea. Attorneys' fees are too high. Homeowners shouldn't be subjected to onerous and burdensome legal fees when the homeowner did nothing wrong other than be a little bit late with their assessments. Yet then the attorney's fees were thousands and thousands of dollars. And this is the story. And so there's a germ of an idea, and that gets turned into a bill. I mean, this is Schoolhouse Rock in the 80s. How does a bill become a law? Well, it started as a bill, and it's on the steps of the legislative body, Congress, in this case, the Arizona legislature. And it has to go through the House and then the Senate, voted on by a majority of both sides, and then signed by the governor. And That's the genesis of an idea. Well, if the stakeholders hate it and they threaten legislators with you won't be reelected, there won't be any money for your reelection, then perhaps it won't pass. So this is what happened this year. So what I'm going to go through today is every bill that passed that touches on community associations, maybe one that you might argue, well, that shouldn't be there, but we'll get to it in a minute. But I do want to touch on a bill that did not pass that would have dramatically changed the governance of community associations. And while it looks like it's about lawyers, it really isn't. It's about trying to bankrupt associations and change the way community associations operate and perhaps end community associations altogether. So we'll start with the one that didn't pass, and I'm concerned to even present it for the reason that it could create confusion, because if I present it at all, someone might leave the presentation or have it in their head that it did pass, and that makes me nervous. So I'm going to be trying to be extremely clear about the one that didn't pass. All right, so we have this Latin phrase, sine die, for the last day of the legislative session. And it creates a countdown of sorts, 90 days till the effective date of the bills that did pass. June 27th is the last day of the legislative session. Not too long ago, if you're counting, today's July 15th, 2025, the legislature's last day, June 27th. So all the bills that did pass that I'm going to talk about, I'm going to talk about one that didn't, Friday, September 26th, 2025. So for the bills that did pass, if you want to get in any behavior that's going to be banned on September 26th, we have a couple of months to get it in under the wire. So the bill that didn't pass, House Bill 2865 in blue, because if you want a copy of this PowerPoint, you can send an email to info@carpenter.law and ask for a copy. The reason it's in blue is because it's a hyperlink. If you were to get a PDF of this presentation, you could click on it and you could go to the actual bill. House Bill 2865 did not pass. Everything on this PowerPoint page is not going to be law. It was introduced by Representative Neil Carter, a conservative Republican in Republican leadership, decided that it would be a good idea to prohibit owners from being required to reimburse legal fees and costs created by their own violations, whether it's a failure to pay assessments or a covenant violation or rule violation. So for those of you in professional community management, or if you're on a board of directors, you know that one of the most important rules we live by in Arizona community associations, and in fact in all community associations across the country, is that if you violate the CC&Rs, if you don't pay your assessments, if you violate the covenants, if you park a boat in the driveway, and the association has to hire an attorney, that generally the attorney's fees incurred by the association are going to eventually end up on the owner's ledger, either right away or because a judge is going to order that those legal fees belong on the ledger. And on the ledger, by that I mean that the owner owes the association the reimbursement, that the owner is going to be adjudged, ordered to pay the association the reimbursement of the legal fees. It's one of the most important rules we live by. The owner is going to be obligated to reimburse the association the legal fees. It's one of our most important rules. It's not just important to the lawyers, it's important to the association that the bad actor be responsible for the legal fees that the association incurred bringing about compliance. Now, Neil Carter decided that this is a bad rule, that it should be flipped on its head, that the association should find the money to bring about compliance and never force the bad actor homeowner to reimburse the legal fees. That the innocent owners who contributed the good funds to the association should absorb the cost. Absorb the cost of the bad actor homeowner who didn't pay the assessments, who violated the covenants, the CC&Rs, or violated the rules, and required the association to hire the attorney and incur the legal fees. That did not pass. Meaning it did not pass both the House and the Senate, and it was not signed by Governor Hobbs. It did, however, pass the House of Origin. We know it started in the House because it's called House Bill 2865. It receives its name and number from the House of Origin, and Neil Carter is a member of the House of Representatives. It did pass the House with 70% of the members in favor. Bipartisan support. The Democrats voted for it too. It stalled in the Senate. It stalled in the Senate because of lobbying by the stakeholders, previous slide. Will it be back next year? Well, we don't know for sure. Can the stakeholders convince Representative Carter to not bring it back next year? I don't know. We'll try. But he feels pretty strongly about it. He has data to suggest that most people nationwide are unhappy with their community associations. According to him, he's got data to suggest that most people are unhappy with their associations. If that's true, then that's not directly on point with the content of the bill. This right here. I mean, if people are unhappy, that doesn't directly translate into this public policy right here. So we don't know what's going to happen. But again, I highlight this was proposed. It did not pass the Senate. It was not signed by our governor. It's a conceptual framework that did not pass the 2025 legislature. But it's not a fair summary of what the legislature did this year without highlighting this disruptive idea. If it had passed, why would it have spelled some doomsday scenario for community associations? Well, people started to not pay, and then people nudged their neighbors with their elbow at a barbecue. Hey, I didn't pay, and I'm not sure what the association is going to be able to do about it. I mean, eventually, I'm not sure where the association is going to find the money. Eventually, the association will run out of money. Some of you have been around since the Great Recession, now 15 plus years ago, when most attorneys did collections on a fee-for-service basis. Perhaps we're back to that because of the difficulty garnishing wages and doing routine justice court cases. But back then, everything was fee-for-service, and the music stopped with the Great Recession. People were losing their homes to their lenders because of foreclosures, tumbleweeds going down neighborhoods. It was a difficult time for associations, professional management, and for law firms. And eventually, associations ran out of money. Eventually, what would happen here is that some enforcement would happen, enforcement of the assessment obligation and enforcement of the obligation to follow the CC&Rs on routine covenant requirements. Attorneys would get paid initially. But when the attorney's fees cannot be charged back to the owner in either context or any context, associations would stop hiring lawyers. And lawyers like me would eventually have to figure out how to become experts at putting associations through bankruptcy court, I think. But we don't have to worry about it right now. But eventually, if something like this were to happen, it would feel like this bill or a bill like it is an attempt to put associations out of business and make it impossible for associations to collect assessments or enforce the covenants. Essentially, another way to put associations out of business, just without saying it. So again, didn't pass. We'll see what happens. Another bullet point of overview of the 2025 legislative session. So let's talk about what did pass. Final bullet point of overview, forgot I had this point. The most conservative Republicans want to regulate community associations most assertively. I've noticed this over the decades that I've been a volunteer lobbyist. I'm not sure why. I was a political science major in college, and I've never figured this part out. You'd think that the most conservative Republicans, and this is just a point of political ideology and trying to figure it out, the most conservative Republicans you'd think would want smaller government and less regulation. Yet I've observed that, at least in Arizona, the most conservative Republicans want the most regulation of community associations. And I've tried to figure it out. I've even asked some of them, and I cannot figure it out. I've tried again. I've tried many times. I cannot figure it out. Okay, let's talk about the bills that did pass. The first one has to do with condominium commercial structures. House Bill 2322. If a majority of the units in a condominium are designated for commercial or work purposes and are separate from a residential structure in the condominium, provided that no residential units are located above or below the commercial structure, so they're not stacked, then a common expense or portion of a common expense that exclusively benefits the commercial structures must be assessed exclusively against the units in the commercial structures, and a common expense or portion of a common expense that exclusively benefits the residential structures must be assessed exclusively against the units in the residential structures. So it's pretty simple. This is an odd one. It feels like someone owns a unit in a very particular condo where there's mixed use. And this describes one particular condominium project where a majority of the units were designated for commercial work purposes, and it's separate from the residential. In this particular condo, which I don't know which one it is, they were not separating the expenses in exactly this manner. And so this owner or group of owners went to the legislature and said, we're frustrated because the condo is not separating the expenses into a commercial budget and a residential budget, which could have been done under the existing statute, 33-1255C2, not to get too into the weeds here. But under the current Condominium Act, this result could have been obtained without this bill. But there are very few condos where a majority of the units are commercial or work purposes, and then there are also residential units. But this, be that as it may, if there's commercial units and residential units, and the commercial and the residential are not stacked above and below each other, we have to have a commercial budget and a residential budget. So this won't apply to very many, but for the sake of being complete, This is effective September 26th, 2025. All right, small claims court jurisdiction. The current jurisdictional limit is $3,500. Now remember, lawyers cannot go to small claims court on behalf of a client. If I have a personal dispute in my personal life, I can go to small claims court. I can walk in there. I will not be banned. If I have something going on at my house and I have a dispute with a vendor or a contractor, I can go to small claims court. I cannot go to small claims court on behalf of a client. I'm prohibited as a lawyer. But management companies can go to small claims court on behalf of a client by statute. Today is not about that. Today is about the jurisdictional limit, which is currently $3,500 and will be $3,500 until September 26th, 2025. The new jurisdictional limit is $5,000 for your principal amount of the dispute. Recording of open meetings. I've done a couple of seminars. I do these every month. The last two, I have spent a minute or two at the beginning about this one because I'm a little frustrated with it. I'm not going to go on my usual tirade, but I will mention a few of the issues. As a reminder, owners have had the right to record open meetings with their own devices since 2011. So for 14 years, owners have had the right to go to a meeting and record with their own devices since 2011. A number of years ago on a Friday night, I went to a board removal meeting and someone got in my face with their phone and they were live streaming me on Facebook Live. And one of the board members said, "Hey, you're being streamed on Facebook Live." And I made a joke to him. He was friendly. I'm hideous. I didn't know I needed to be camera ready. And of course, I don't wear makeup. I was kidding about being camera ready. This is the real me, even for these times that I spend in the studio for webinars. But owners have the right to record. And I'm talking about streaming. Streaming is a different thing altogether. The statute does permit rules and regulations, and boards should give thought to the difference between recording and streaming. These are different things. And social media and posting the content of an open meeting is different than the way the statute was enacted, which was the idea that an owner could record it to a device, which is entirely different than live streaming or posting to YouTube for some other purpose, often to advance the homeowner's personal interest, or at times for parody purposes, or to make fun of it, or for some other purpose. A social media policy can help in that regard, but that's a different topic, perhaps for a different day. Today, the goal is to let you know what the legislature did, and I'm off topic. So let's get back. Talking to myself. Owners have been able to record open meetings with their own devices since 2011. During the pandemic, as you know, many associations started using Zoom, Teams, GoToMeeting, whatever, and started recording meetings purposely or accidentally and retaining the recordings. I say accidentally because some boards didn't know that Zoom, for example, I use Zoom, you're on Zoom right now, has a setting where the management company might have intentionally or accidentally recorded the meeting to the cloud, and it's retained there. And I don't mean to disparage anybody, but sometimes things are recorded accidentally. It's just a click on a screen in your web-based app, and you don't even know that you're recording it to the cloud, and then the association has it. But it's not retained on an association server or computer or management company computer or server or management company cloud platform. It's in the Zoom cloud. My seminars, my webinars, which I do record, are in the Zoom cloud after today. So these recordings, an owner can use the existing statutory books and records access framework to request a copy of the unedited recording. And I've given you the statutory references in a condo and in a planned community. But let's remind ourselves what those statutes say. Both statutes say in the old days, because the statutes are now outdated, if an owner wants access to the books and records, the old days, a steel filing cabinet in the corner of the clubhouse. Owner asks for access to the records. The association has 10 business days to provide access for the review. And then the owner goes in and puts yellow Post-it notes on the documents the owner wants to have photocopies of. So there's 20 business days here that the association could play games with. Shenanigans, I guess you could say. So when the legislature said, okay, we'll use the existing statutory books and records access framework to request a copy of the unedited recording, that's a 20 business day delay, because the original version of the bill said immediate access. It wasn't the word immediate, but it was basically you have to provide a copy of the unedited recording. It was the functional equivalent of immediately. This wasn't the word, but the original version of the bill was right away or immediately or something like that. It doesn't matter because it's not the language we ended up with in Senate Bill 1039. But the compromise was, okay, we can't do it immediately. Use the existing books and records access framework from the books and records statutes. So it got switched out, which is good. But now it's essentially a 20 business day delay. If somebody says, well, I know you recorded the meeting and I want a copy, it's 20 business days. Now, the other thing that I've talked about a couple of times is that the statute says the board of directors records the meeting. What happens when Bob, the secretary, records the meeting on his personal device? The association does not have possession of that recording. Bob did not send it to the management company. Bob didn't send it to anyone else on the board, but someone in the audience saw Bob recording the meeting. And how can the association provide a copy of Bob's audio file on his phone? We know that a voice note recording on an iPhone has no limit to the length of the recording other than the amount of memory on the phone. If the meeting's an hour, an iPhone can handle an hour-long recording if there's enough memory on the phone. And in fact, if there's enough memory on the phone can handle a 2 or 3 hour meeting, just a standard iPhone. And there are other recording devices, depending on the chip. This is a micro SD card. If it has enough memory on another kind of recording device, These recording devices can handle hours and hours of recording. So the other glitch in the statute is Bob's the secretary. Bob records the meeting on some kind of device to some media. Bob takes it back to his unit. Sally in the audience wants a copy, but the association has no possession or control over the data file. How can the association produce it? Bob resigns from the board. Bob doesn't want to hand it over. There are potential litigation scenarios here. Now, I'm a lawyer. I can dream all this stuff up. That doesn't mean it's going to happen, but it could. And that's why there's danger in solving problems that are not big problems. If you were to go to the legislature's website and watch the recording of the committee hearing that gave rise to this bill, you'd hear a gentleman tell his story where he knew the meeting was recorded and he asked for a copy. And as far as he was concerned, there was just a little too much friction over it. And so he went to his legislator and said, there ought to be a law. And the legislators at the hearing said, you know what? You're right. There ought to be a law. And so we have Senate Bill 1039, not drafted perfectly. Now we have the 20 business day issue. And we have the problem of how does the association control or gain possession of or compel Bob, who recorded the meeting on his own device? Now, why did Bob do that? Bob's on the board. Why did he record it? Well, any of you on this webinar who've been around for a while know Bob's got a hearing problem. He's supposed to take the minutes. He recorded it for his own purposes. He recorded it to make sure he gets the minutes to be exactly right. I say Bob, the secretary, it could be Sally, it could be Barb, it could be anybody, but they record meetings for their own purposes. I've been to many meetings where the first thing that happens is somebody puts a recording device in front of me and says, do you mind if we record the meeting? What am I supposed to say? I said, no problem. I don't know why. They just record it. So Senate Bill 1039, September 26, 2025, 10 business days plus 10 business days, 20 total. Maybe we won't have a problem with Bob recording the meeting on his own device. How many times have I waved this phone in front of you? Or the SD card from some other recording device. But those are the things that we're dealing with in this recording of open meetings issue. Tax deed land sales. I mentioned earlier we included one for the sake of being complete. If there's real property owned by the state by tax deed, the state can sell it to a homeowners association if the property is part of a common area maintained by the homeowners association as determined by the county assessor. This one was flagged early on by lobbyists and tracked for its inclusion of the word homeowners association. I don't know the history much here. We've tracked it from the beginning. If it comes up, it'll be because the county assessor and the state proposed to sell common area to a homeowners association. And when it comes up, we'll deal with it then. I'm not sure it's going to be something that comes up because associations bring it up. I forgot to put the bill number on this screen. My bad. Before I turn this into a PDF, I'll include it. So it won't, it'll be, the mistake will be invisible to anybody who asks for a PDF. info@carpenter.law. No, that it is there. Okay, just my rolling animations were a little bit out of order. So it is there. Political signs. Never underestimate the power of the legislators to create statutes that help themselves. They've done this periodically where they've created statutes that allow political signs in more and more places so that they can get reelected, so they can get elected. And so this time, every place in the regulatory scheme where they have given themselves the right to put political signs. Now, if there's a regulation that allows a political sign, now it includes a political flag. So if the idea is Carpenter for Senate, and I have that in the form of a political sign, if Carpenter for Senate is now on a political flag, that's permitted. I'm not running for the Senate, by the way. I have no political aspirations whatsoever. Maybe in my earlier life, I thought, no, maybe I could be a politician one day. But that is no longer part of my life ambition. Just an example. Politicians do not miss an opportunity to protect their own interests. It helps them have an opportunity to plant a flag or advertise their candidacy or stake their claim. Now it's a flag. So Trump 2024 in the form of a political sign protected. Now, if they want to put that on a flag, that's protected too. All right, common expense lien and foreclosure, Senate Bill 1494. What I'm about to tell you is sort of a big deal, but I was surprised as this bill made its way through the legislature that one of the things the legislature has consistently done over the years is whatever they regulate, they do a mirror image for condos and planned communities. What they do for one, they do for the other, which they did here. They made sure that whatever they did to political signs and political flags in condos, they did it to planned communities. Yet over here, one of the most consequential changes they've ever made to liens and foreclosures, they didn't do to condominiums. They did it for planned communities only. I'm currently handling one of the largest, most expensive foreclosure cases I've ever handled in 31 years. The attorney's fees are off the charts. The homeowners never paid a penny of assessments. It's in a planned community, and we would file it even under these new rules, but the changes they're not making as a mirror image in the Condominium Act. So for planned communities only, a common expense lien may be foreclosed only if the owner has been and remains delinquent in the payment of any assessment or portion of the assessment for 18 months or in the amount of $10,000 or more, whichever occurs first, as determined on the date the foreclosure lawsuit is filed with the Superior Court. Currently, we're at $1,200 on the 10,000, and it's a big change, and so we've got to be careful. So if you have someone who's delinquent shorter than 18 months, but at least 12, and less than 10,000, but more than 1,200, we need to be filing these before September 26th, 2025. The legislature has created, they've created a real opportunity and a real incentive to file foreclosures right now. We need to get moving on these eligible foreclosures between now and September 26th, 2025. Whether they intended to do that or not, that's the alignment of the incentives. And it probably creates an incentive to take a hard look at all the condo delinquencies too, just because it's probably a matter of time before somebody figures out that this was an accident, that they did not mirror image this over to the condominiums as well. Most public policies that the legislature enacts, they do on both condos and planned communities. So this is a big deal. There are some creative ideas that are floating around out there to deal with this, but there are no creative ideas that are foolproof. But it's one of the most consequential attempts to make it difficult for associations to collect assessments. We know that since 2022, when the citizenry changed the garnishment statute, that collecting assessments through personal money judgments and garnishing wages has been much more difficult. So there's been a renewed focus on foreclosure as the most viable way to collect. So it's not a surprise that the legislature would react to that. But by doing this, and it forces us to look at, well, what's the alternative to this? What, going to justice court and getting a judgment and trying to garnish wages? Well, that's difficult too, because unless the person has a W-2 job making significant wages, collecting against someone either takes a tremendous amount of time or we can't garnish. Remember, we can't garnish wages against someone who's a consultant or has a 1099 job or owns a business. And like me, I don't have a W-2. There's no one here to garnish my wages. I don't earn money that way. When you own a business, it's not the way to do it. So we end up in a difficult circumstance. The property's owned by an LLC. You can't garnish wages off of a justice court judgment. So people have figured this out, or it's just the circumstances where collecting on a justice court judgment has become difficult. So this one, I didn't mean to leave the more difficult one for the end, but we have difficulty with this one because if the legislature did this to intentionally force associations to get personal money judgments and garnish, that option has already become more difficult. All right, so that's the presentation. Like I said, happy to send the PDF. I also have a changes in the law handout. I was trying to figure out a way to attach it to this presentation, like in a chat or something. I was having trouble with that too. If you send an email to me at scott@carpenter.law or info@carpenter.law, I'm happy to send both. All right, I have a few in the Q&A. Let's see what I can do here real quickly. Representative Carter's reasoning for this bill, we're not sure. I've met with him several times about it. His reasoning was people don't like their HOAs, but he never really got beyond that. He never really explained that idea that the innocent owners should pay for the sins of their violating neighbors. And he never really explained, he's a practicing lawyer, by the way, but he never really explained why the complying and innocent owner should pay for the bad deeds of the offending owners. It never really got to that point. He wanted to hear from the stakeholders more than he wanted to explain himself. On the recordings, a good question. Isn't Bob's recording of a meeting no different than an owner who records the meeting? Can't Bob claim that it's his personal copy and under no obligation to share his copy, the recording being an unofficial association recording? If an owner records a meeting, can that owner equally responsible for releasing their copy? It's a good question. The problem we have under the recording statute is that the statute says, it states that if the board of directors records the meeting, and I'm concerned that if one director records the meeting, then under the statute, that belongs to the board, especially if Bob is the secretary recording the meeting. If there's no official recording that one director and the membership watches Bob, the secretary, record the meeting, I have trouble with the position that the association didn't record the meeting. Bob, the secretary, sitting at the board table, recorded it, and that's his personal copy. But I appreciate the question. Unless we see it happen and the association wants to try to shield Bob from having to disclose it because that's his personal copy, we won't know the answer, but it's a good question. Explain what happens if filed after the date. Perhaps this means a foreclosure filed after the date. I'm not sure this question. If we file a foreclosure after the date, I'll assume that's what this means, but it's less than 10,000. Yes, okay. Thank you for the clarification. If we file a foreclosure after September 26th, but it's less than 10,000, we run the risk that the owner will defend him or herself by saying this lawsuit is wrongful because the statute says I have to be delinquent $10,000 or at least 18 months. Therefore, the lawsuit should be dismissed. And we would be at risk that the lawsuit would be dismissed or put on what's called an inactive calendar until the owner is delinquent 18 months or $10,000. And it seems like the owner would work hard to never be delinquent 18 months or $10,000. So I think that's the risk if we don't hurry up and get everything that we can filed before September 26th, 2025. That's the that's the inherent risk as we approach the September 26th, 2025 date. As I close today, since I've gotten through it somewhat quickly, which is good, we didn't have as active a year. The theory before the legislature started was that because we had a lot going on last year in 2024, that 2025 would be a quiet year, that the leadership had said, hey, perhaps this won't be as active a year. Perhaps we can keep the HOA bills to a minimum. And then all of a sudden we end up with this foreclosure stuff. And perhaps that's the biggest one that I left for the end because it's kind of a big deal. It would have been a bigger deal if it had also applied to condos because condos tend to have higher assessments. So at the end of the day, I think we survived this legislative session pretty well intact. The big bullet we dodged, of course, was this House Bill 2865. One last time, it didn't pass. We'll see what happens in the legislative session next year, but hopefully it will not be back and we can convince Representative Neil Carter that there's no reason for it to come back next year. Thank you all for attending. We do these every month. I can't remember what my seminar is in August, but happy to have everybody back in August for our next webinar. Thanks.